Section 43. No balance billing for indigents in government healthcare institutions. No other fee or expense shall be charged to indigent in government healthcare institutions, subject to the guidelines issued by the corporation. All necessary services and complete quality care to attain the best possible health outcomes shall be provided to them. Healthcare institutions must give indigent members preferential access to their social welfare funds, which may be used to augment the benefit package provided. In case of insufficiency, to fully cover all confinement charges. Healthcare professionals must not charge over and above the professional fees provided by the program for members admitted to a service bed. The no balance billing may also be extended to other member categories as defined by the corporation. In Section 46, it states that reimbursement and period to file claims All claims for reimbursement or payment for services rendered shall be filed within a period of 60 calendar days from the date of discharge of the patient from the healthcare provider. The period to file the claim may be extended for such reasonable causes as may be determined by the corporation. Quality assurance and accreditation. Rule 1. Quality assurance. Section 50. Objective. The corporation shall implement a quality assurance program applicable to all healthcare providers for the delivery of health services nationwide. This program shall ensure that the health services rendered to the members by accredited healthcare providers are of quality necessary to achieve the desired health outcomes and member satisfaction. Section 53. Types of accreditation. The accreditation shall be of the following types. A. Initial accreditation. This shall be given to qualified healthcare providers that are applying for the first time. The accreditation shall take effect upon the compliance of the requirements. If the facilities are revoked, institutional healthcare provider are transferred either by sale or lease or such other modes of transfer, such will be treated as an application for initial accreditation. B. Continuous accreditation. This shall be given to accredited healthcare providers that applied through basic participation and who complied with the requirements prescribed by the corporation that qualified them for uninterrupted participation to the program, until their accreditation is withdrawn based on rules set by the corporation. C. Re-accreditation. The accreditation that shall be given to healthcare providers under any of the following conditions or any other conditions as determined by the corporation. 1. Healthcare institution whose previous accreditation has lapsed or whose subsequent application was denied. 2. Healthcare institutions that failed to submit the requirements for continuous participation within the prescribed period. Acquisition of additional service capability that would require change in license or certificate as applicable issued by the relevant authority. Number 4. Transfer obligation. The healthcare institution must first secure a license to operate from the DOH for the new facility prior to the date of transfer and apply for a re-accreditation within 90 days from the date of transfer. Beyond this period, the accreditation shall automatically lapse and all claims filed with the corporation shall not be paid. The healthcare institution must inform the corporation of the planned transfer indicating the exact date of transfer and the address of the new site. The 90-day grace period shall not apply to the new site if it is not licensed. 5th, upgrading of facility level or category. 6. Change in the classification of healthcare institution. 7. Change of ownership. 8. Resumption of operation after closure, cessation of operation. Professionals whose previous accreditation has lapsed or whose subsequent application was denied shall be re-accredited. When the accreditation of healthcare institution lapsed due to a voluntary act of healthcare provider to evade the consequences of a previous violation or adverse findings indicating fraud as determined by the corporation, the application for re-accreditation shall be denied. D. Reinstatement of accreditation. The restoration of accreditation after compliance to conditions following a suspension imposed by the corporation. In Section 55, it talks about healthcare providers. The following healthcare providers shall be accredited before they can participate in the program. A. Healthcare institutions. Example, hospitals. Number 2, outpatient clinics that includes rural health units, health centers, dispensaries, infirmaries, birthing homes facilities, medical outpatient clinics, other primary care facilities licensed by the DOH. Number 3, freestanding dialysis clinics. Number 4, ambulatory surgical clinics. MHOs or Health Maintenance Organizations, CBHCO or Community-Based Healthcare Organizations, pharmacies, other healthcare institutions licensed by the DOH. For letter B, the healthcare professionals that includes physicians, dentists, nurses. Of course, it includes midwives, of course, pharmacists. They are considered healthcare professionals and other duly licensed healthcare professionals. Section 56, Accreditation Requirements for Healthcare Institutions. The following requirements shall apply to healthcare institutions in appropriate cases. A. They must have been operating for at least 3 years prior to initial application for accreditation with a good track record in the provision of healthcare services. The date of reckoning of the 3-year operation requirement shall be the effectivity date of either the initial license, clearance to operate, certificate, or other proof of operation issued by the DOH or other pertinent government agencies if applicable. HCIs that have temporarily stopped operation due to upgrading, expansion, change of ownership, or other causes shall have their length of operation computed on a cumulative basis from the date of the initial operation of the former institution. B. They must be licensed or certified by the DOH. C. They must comply with the provisions of the performance commitment. And of course, letter D, any other requirements that may be determined by the corporation. Section 61, Accreditation Requirements for Physicians, Dentists, Nurses, Midwives, Pharmacists, and other licensed healthcare professionals. Physicians, dentists, nurses, midwives, pharmacists, and other licensed healthcare professionals shall comply with the following requirements to be accredited. A. Duly licensed to practice in the Philippines by the PRC. They must be members of the program with qualifying premium contributions. Comply with the provisions set forth in the performance commitment for professionals, and must comply with any other requirements that may be determined by the corporation. No accreditation fees shall be imposed by the corporation for healthcare professionals and shall not require a certificate of good standing or such other analogous certification for them to be accredited. Findings on ethical issues by disciplinary bodies of accredited professional organizations of the PRC or specialty societies recognized by PMA in case of medical specialists shall be considered in assessing the performance of healthcare professionals. Suspension of membership such as professional organization shall be given due consideration in assessing the continued accreditation of such professionals. Section 71. Creation of the National Health Insurance Fund. There is hereby created a National Health Insurance Fund, hereinafter referred to as the fund, that shall consist of A. Contribution from program members, other appropriations earmarked by the national and local governments purposely for the implementation of the program. Letter C. Subsequent appropriations provided for under sections 46 and 47 of the Act. Letter D. Donations and grants in aid. And letter E. All accruals thereof.
So what is a quasi-judicial process? The quasi-judicial process is to conduct investigation for the determination of a question, controversy, complaint, or unresolved grievances. They issues orders or resolution and render decision accordingly, and it shall proceed to hear and determine cases in the presence of all concerned parties or even ex parte with due notice to all parties. So the healthcare prosecutors will be the one who will conduct PI or preliminary investigation on complaints filed against healthcare providers or Philhealth members. If a prima facie case exists, the prosecutor issues a resolution and files the complaint before the Philhealth arbiter. So what is the authority of the adjudicator of the corporation? So they are the one who shall exercise original and exclusive jurisdiction over all complaints filed with the corporation in accordance with Republic Act 7875. As amended and these rules, they shall have the power to administer oaths and issue subpoenas and such other powers vested in them by Republic Act 7875 as amended by Republic Acts number 9241, 10606, and 11223 and its respective implementing rules and regulations. So, who may file a complaint against healthcare providers and or members? Any person, natural person, or juridical person. What are the grounds of complaints against healthcare providers and or members? So, the commission of any of the offenses enumerated in Section 38 of RA 11223 and Republic Act 7875 as amended under IRRs and other rules prescribed. So, the venue of filing a written complaint may be filed before the Office of Philhealth. Yeah, so in case of recommendation for filing a complaint affidavit and its annexes shall be filed with prosecutor department in one original copy and or certified true copy and 3 copies per respondent within the prescribed period. So for complaints or reports filed directly with the prosecutor department, it shall conduct a PI and issue a resolution with its recommendation on whether to dismiss the complaint or to file the case within 60 days. Upon receipt of the complaint affidavit, the prosecutor shall immediately conduct the preliminary investigation. So the prosecutor may base on the examination of the allegation of the complaint, affidavit on the other supporting documents or evidence, outrightly dismiss the same on any of the following grounds. First is for lack of jurisdiction over subject matter and or parties involved, failure to state a cause of action or sufficiency of evidence. So the directive to file an answer. So the prosecutor shall issue the corresponding directive to the respondent healthcare provider and or member, directing the same to file a verified answer to the complaint affidavit, triplicate copies within 10 working days from receipt of the directive. So in case of HCP members fails to submit an answer within the reglementary period despite proper notice, the prosecutor shall resolve the complaint based on available evidence on record. So these are the following pleadings that shall not be allowed. First is the motion for reconsideration, motion to dismiss, except on the ground of lack of jurisdiction under the subject matter, the failure to state a cause of action if the action is barred by res judicata or statutes of limitation, and all other pleadings that may unnecessarily delay the proceedings before the prosecution department. So upon the approval of the resolution, the FFIED and or PRO shall be immediately furnished with the same, and the prosecutor shall find the appropriate formal charge with the adjudication office within 5 working days from receipt of the approved resolution. So the finality of resolution. The resolution of the prosecutor duly approved by the SVP LS shall be final. So no appeal of or motion for reconsideration or any other similar pleadings shall be entertained.